Are you feeling camera ready? Photo attorney Carolyn Wright is here. Wendy Seltzer is going to talk privacy and comical DMCA takedowns. Matt Buchanan makes sense out of the patent mess for us. I'm out of town, but Evan Brown is an excellent driver. Next on This Week in Law.
Netcasts you love.
From people you trust.
This is TWiL.
Bandwidth for This Week in Law is provided by Cachefly at CACHEFLY.com.
This is TWiL, This Week in Law with Denise Howell and guest host Evan Brown. Episode 124 recorded August 12th, 2011. Ready for your close-up. This episode of This Week in Law is brought to you by Netflix. Watch thousands of TV episodes and movies on your PC, Mac, iPad, iPhone, or TV instantly. All streamed directly to you, saving you time, money, and hassle. For your free 30-day trial, go to netflix.com/twit.
Hey, everybody, and welcome to episode 124 of This Week in Law. I am Evan Brown, and I have the honor of hosting the show this week while Denise is out. And all week I've really been looking forward to having the conversation that we're going to have today. A great panel of really smart people, very interesting people coming from different perspectives, different doing different things. I'd first like to introduce you to Carolyn Wright. Carolyn, you have been on the show before. It's great to talk with you again. How's it going today?
It's going great. Thanks. Glad to be here again.
Great. Carolyn is an attorney. She's known as the photo attorney. You can visit her site at photoattorney.com, and your practice is aimed, as you described, squarely at the needs of photographers. A very interesting niche for your practice, and also I might add that you're a professional photographer yourself, right?
Right, and actually I'm headed to teach a photography workshop in Alaska next week. We're going to go photograph coastal brown bears, commonly known as grizzly bears.
Oh, that's nice. That's great. And if you check out Carolyn's blog, you see all kinds of wonderful images that she's taken, that you've taken, Carolyn, wildlife and nature photography. Very impressive stuff. So welcome to the show. Thanks for being here.
Thanks.
Also returning to the show, Matt Buchanan. Matt, how are you today?
I'm doing well, Evan. How are you doing?
Doing all right. Great to talk with you again. Matt is one of the founding members of the law firm Buchanan Nipper LLC, and you're over there in Ohio, right, Matt? Perrysburg, that's where you are?
That's right. I'm in Perrysburg, which is a suburb of Toledo, which is half an hour south of Detroit.
I'm glad that you said that. I was, we were going to have you on the show a couple of weeks ago, or whenever that was, and I got to Perrysburg as a suburb of Toledo, so as if Toledo was not worthy of having suburbs. So I'm glad you said it. I'm glad I didn't have to ask you to confirm that. So as you describe your practice, you help innovators build business value around their intellectual assets. A great way of describing it, and your website is bnip.com. You're partners with Steve Nipper, right?
That's right. Longtime friend Steve Nipper, who's actually in Boise, Idaho. So we've got an office in Perrysburg on the right side of the country and in Boise on the left side.
That's great. That's a great model for a law firm, and you're really doing a good thing. So really happy to be talking with you today. Finally, I would like to introduce everyone. Also, everybody here, as I've said, is a return visitor to TWiL. Wendy Seltzer. Hi, Wendy.
Hi. Good to be here.
Hi. Yes, and Wendy, you are, in my view, you really have the quintessential law and technology career. And everybody who's not familiar with Wendy's work, you really should be. She is a fellow with Princeton's Center for Information Technology Policy, had previous stints with, among others, Harvard's Berkman Center for Internet and Society, the University of Colorado's Silicon Flatiron Center for Law, Technology, and Entrepreneurship. She was a staff attorney with the EFF, so wonderful stuff. Also, she's a founder of chillingeffects.org, that great website, that great place on the web that collects and analyzes legal threat letters, particularly DMCA takedown notices. And Wendy's also very involved with ICANN, with the domain name governance, and also open source software and Creative Commons. So wonderful, really wonderful to have you on the show, Wendy. Thanks for coming back.
Thanks. Unfortunately, Chilling Effects has been busier than ever lately with more and more takedown notices pouring into the various sites that we collect them from.
Yeah, good. Well, let's talk about those. As we're going along here, and maybe we can start off with a topic here that will allow us to segue into some of the things that you're seeing an uptick of at chillingeffects.org. What I want to use as kind of a groundwork or as a substrate here to get us talking about some of these modern issues with copyright on the web is this story that was kicking around earlier this year, and in particular last month. It's the situation with Andy Baio, I'm not sure how you pronounce his name, but he's an entrepreneur, tech guy up from the Pacific Northwest, and he produced this album, this work, called Kind of Bloop, which is an 8-bit chiptune rendition of Miles Davis's famous album Kind of Blue. And Andy did the right thing when it came to the music licensing, but he also wanted to finish off the work by making an 8-bit rendering of the album cover, which contains as its feature a very recognizable photograph of Miles Davis taken by photographer Jay Meisel. And Baio, I'll just refer to him as Baio, unless anybody knows for sure the correct pronunciation of Andy's name. Baio didn't get a license in the photograph, but instead relied, perhaps after the fact, on the idea of fair use to render the work on the album cover as 8-bit kind of art here. And so I'm wondering what your guys' thoughts are along these lines, because what happened here is the photographer, the copyright owner in the photograph, sent a cease and desist letter to Baio, and they eventually resolved the dispute with Baio paying some money. And so they didn't have to litigate this. But there's this really tricky, and there still seems to be this fundamental disagreement between the two parties as to whether or not this really was a copyright infringement using this 8-bit work. So, Carolyn, if you've had a chance to look at this, what are your thoughts about coming from the perspective of the interests of the copyright holder? How would you approach a general kind of situation like this, where a photographer is upset about the subsequent reuse of his or her work?
It happens a lot in my practice, as I mostly represent photographers, and a lot of our practice is spent on time doing copyright infringement cases. And so this idea of whether a use of an image is a fair use comes up all of the time. In summary, I don't think this was a fair use. I know that there are proponents that it was a fair use, that it wasn't a replacement of the original photograph. But essentially what Baio, I guess, we're going to pronounce it that way, Baio did was just run the image, scan the image, and run it through a filter, posterized it or posterized it. It depends on how. Again, is Baio or Bio? I'm not sure.
As long as we don't refer to him as Scott, he's not Scott Baio. So.
Exactly.
Or Chachi, for that matter.
That's right.
Made some minor filter changes to the image, and then used it for the cover of the image. Whether it's fair use is tough to decide. He used the entirety of the image. It was used in the same way as the original image was used. I think that if I were counseling anybody who was going to use an image like this, I would say, look, it's easier and a lot cheaper to ask for permission. I mean, how much would Maisel had asked for a license to use his image, or aren't there other, how much would it have cost to get an appropriate license as opposed to on the back end having to pay a settlement in order to avoid formal litigation? But you've got to look at all the fair use factors, and you've got to look at other cases to see how the courts have handled it. But in summary, I don't think it was a fair use at all.
Well, Wendy, I'd like to ask you about this and what your thoughts are along these lines, because in this situation, the artist, Mr. Baio, wanted to use this photo, and indeed he did. He made a derivative work out of it by pixelating it or whatever, posterizing it, whatever technique he used to render it in a quote unquote lower quality format. It turns out that the photographer was not willing to license the work, or at least that's what he's saying now. He's like, it would have been degrading to my work. I'm paraphrasing, and I would have never licensed it, never allowed it to be put in this way. Wendy, can you think of a meaningful way for a creative person like Mr. Baio in this situation to fully exploit or enjoy the rights to a fair use of a work when there's so much uncertainty as to whether it would be a fair use, and indeed turns out that there would have been no meaningful opportunity for there to be a licensing arrangement? What are your thoughts on that track, Wendy?
Well, respectfully disagree with Carolyn that the first response should always be to seek permission, because I think the very heart of what fair use is supposed to protect is the leeway to make transformative uses without asking permission, without asking a copyright holder, are you okay with my parody of your work? Are you okay with my taking your work and putting it into a different context? When the use is something that is commenting on the original. I think that as the tunes that were included in the album were degraded or different resolution versions of the original music. This was a low-resolution, grainy image of a photograph that was commenting on, is this a recognizable person or is this something new? The only way to make that commentary is to use the original and to use the entire original as the basis for transformation. So I think he was taking what he needed to take to make that commentary and then making something different from it, which is the heart of what transformative work under that fair use first factor is. And then when the artist, when the photographer says he wouldn't have granted permission, I think that's a direct acknowledgement that the fourth factor, effect on the market, can't be found, because if there's no market, then this wouldn't affect it. It's not substituting for licensing that would have been permitted. And it's instead saying he wanted to use copyright as a veto on ways that his work could be used. I think copyright isn't supposed to have that force in a cultural dialogue.
Mm-hmm. Mm-hmm. Can you articulate a meaningful way that a creative person should go about thinking of these things in light of so much uncertainty? I mean, as Carolyn acknowledged, and Wendy, I'm directing this to you. As Carolyn acknowledged, it can be a difficult process to do this stuff, and she suggested that it's the best practice to try to license that. But how do we deal with all of this in the face of so much uncertainty when there's such a public interest in the reuse and the remix of these types of works, with the fact that you don't know whether it's going to be permissible until after you've been sued and raised this affirmative defense that could possibly cost you thousands and thousands of dollars to establish, just to give you the right to go ahead and do what you intended to do. What say you on that, Wendy?
Well, I always encourage creators to think through why they're using a work when they're thinking about making a fair use argument. Are they using it because it's necessary to the work that they're trying to create to use this particular work? Is it necessary because they're making a statement about that work or a commentary? Or are they using it just because it's easier or cheaper to use it without paying than to pay somebody else or find a different source? If they're using it just because it's cheaper and easier, that's not something that fair use is going to excuse. If they're using it because it's necessary to their artwork, then they will often have a fair use claim if they're using it in ways that then don't substitute. I mean, there are places then where I think that the case law has gotten a bit away from what the underlying policy should be, and that we sometimes have created a culture of licensing where, as a matter of policy, I would like to see more opportunity for fair use. I'm thinking particularly of the music sampling case law, where it has gotten to the point that we've created a culture of pay for everything rather than acknowledging that there are some uses that are fair and need not be paid for because it's part of the cultural conversation. But I think that artists and the artists and commentators who reuse material should be thinking about why are they reusing, and if they can tell a strong story about the transformative nature, about the reasons for their artistic and critical need to use a work, then they shouldn't also have to go request permission or make payments for it.
Very interesting. And as we know, the question of whether or not a subsequent use is transformative is a very important inquiry and analysis to be made in determining whether a use by someone else of a copyrighted work is fair. And so in that spirit, Matt, I have a question for you. I'd like to get your thoughts on this. Mr. Baio, in this situation, in creating this album, he went ahead and licensed the music in order to make a derivative work, an 8-bit cover, if you will, this chiptune rendition of the album. He went ahead and got the license for the music, but didn't go ahead and get a license for the visual aspect of it. Does that play into, do you think, the strength of any argument that he might make that one use would be transformative? The use of the visual image would be transformative, a commentary on the artwork, as versus a transformative use of the music that he essentially conceded. Perhaps we could debate this point, may have conceded that it wasn't subject to fair use to make this copy of it. What do you think about that?
Yeah, I think that's an interesting distinction, and that's kind of the practical question I had right after I read about this was, it appears that he went out and went down one path on the music side and went down the other path on the photograph side. My understanding of the technology is it's just kind of a downgrading in quality on both avenues. But maybe he made some sort of assessment that when he went through those algorithms that it did more to the photograph. When you compared his final product to the original, that the downgrading he did more to it to make it more of a transformative work than it did to the music. And maybe he had some sort of comfort level in drawing that distinction to where he thought that, I need to go get a license for the music, but the photograph, I think I'm fine. Or the other possibility is, and I don't know if we know this or not, I don't know if he asked for a license for the photograph and was denied it initially and decided to go forward anyways.
What do you think about that, Carolyn? The question that I posed to Matt about him getting the license for the music but not the license for the photo, would that change the way that you would advocate for a rights holder in this type of situation?
Well, you're going to see my bias here because I think that most photographers, their images are not given the same respect. If you look at a lot of the commentary online about copyright, people talk about movies, protecting copyright with movies or writings, or music, but photographs are often left out, and so I think there's not the same respect given to the photograph that was taken here. And if you compare the original to the use by Baio, there's very minimal done to that image, and it's just in the same context. It's the same it's the same purpose. There's no transformative purpose there, and so it doesn't make sense to me at all that Baio would think that he would need a license for doing a technological change to the music, but he didn't think he needed a license to do a technological change to the photograph.
Wendy, let me pose to you a pretty fundamental question, and that's this. How is this whole analysis, what's the nature of the change of this analysis that comes about from the fact that we're living in a digital age where photographs can be easily replicated and easily manipulated and easily reused? We don't have to go to the darkroom anymore to make a transformative use of an image. It can be done very easily by just about anyone. Tell us in general what your thoughts are as to how that really should affect, how it does affect, and how it should normatively affect this question of use and reuse of copyrighted materials.
I think the change in technology cuts in both directions for creators and reusers. It's easier for creators to get their material up online and shared. Their costs of going through a darkroom and printing out contact sheets and fussing with chemicals are lower. And the costs of reuse and resharing are lower. I think we've seen some photographers take advantage of that by putting Creative Commons licenses on their works and inviting people to share them. And we've seen other photographers who say that's not their choice and continue to restrict access to their works. And I think both of those are legitimate choices. I wouldn't say that everyone should be forced into sharing or into restricting their works. And then I think that you mentioned of cultural conversation, and I think that's very important because our ways of communicating for all of us have become more multimedia. We have more ways of quoting from movies than just repeating lines to one another. Now, nobody has suggested that we should all be sued for copyright infringement if our movie quotations or song lyrics go on for more than a verse. And so as we're now able to include multimedia in those conversations, I think that's a benefit to culture and not just a place for copyright holders to extract rents from the conversation. So I think, to me, that says we need to think more generously about fair use, as well as to make sure that people aren't overstepping and just taking materials rather than paying for them.
Let me hand that question back to you then, Carolyn. How would you comment on the effect of the easy replication and reuse of digital images and how that affects the normative analysis for fair use?
I don't think that the courts have looked at, I don't think they look at sweat of the brow is some of the terminology the courts have used in the past. That doesn't have to do with copyright protection. The courts, if you sweat over a photograph and it takes you 20 years to take, or versus 2 seconds, or you took it with your iPhone, the courts don't look at that as to whether a photograph is entitled to copyright protection. They look to whether it's scenes of fair, whether there's enough copyright protection, copyrightable expression in the photograph. So sweat of the brow, how easy it is, really doesn't come into the equation, I don't think, with fair use. I think the analysis comes down to, while there are the 4 factors, I've recently read a summary of a lot of fair use cases, and they say it comes down to the transformative purpose analysis. And here we've just got a minimal change. Someone scanned a photograph and pixelated it and put it up on a record album, a music album, in the same way that was done for the original. It's a far cry from the Blanche v. Coons case, where you take a part of an advertised photograph that was used for an advertisement and incorporate it into a collage that's a commentary on society. That's such a huge difference here in this compared to this case. And while fair use is can be a gray line, it's not necessarily black or white until a court gives us that black or white decision. I just have a hard time thinking that this was a parody. I mean, if you want to look at a parody case, a clear parody case, you can look at the Naked Gun picture of the pregnant. I'm sorry, I can't think of the celebrities. Thank you. Demi Moore's pregnancy photo with, and then the Naked Gun parody of that. Definitely, that's definitely a parody. This is just way too close to risk, I think, for Bayo. I think he definitely should have found a different way. And I don't think necessity, which was one of the terms I heard in our conversation earlier, okay, there are no other photographs like this, then and the owner of the photograph didn't want to license it, I'm sorry, that's the right of the copyright owner to not give a license for a derivative work. Wait until the copyright expires, then you can use it. But if we force photographers to give up a license just because they happen to be the only person who has the photograph of someone who's deceased or something like, or otherwise this photograph is unavailable, then I'm sorry, you're just out of luck. You're going to have to find a different way to express your to sell your wares or to find a cover for your album.
All right. Well, I'll just go ahead and do the open segue tag here. Someone might say that these strong interests and strongly enforced rights of the copyright holder would have a chilling effect on the reuse and subsequent use of works. Wendy, what would you say about that? And let that lead you into a discussion of what is the nature of the increased activity over at chillingeffects.org is all about these days. Talk about that.
Sure. Chilling Effects is a website where we collect threat letters that people have received over their activity. Some of them legitimate, proper statements of the law directed at infringing or other wrongful activity. Others, letters that go overboard. And the site aims to help people resist the chill when the threats are unfounded by giving them facts, frequently asked questions and answers about the law, and put the law in more layman's terms for somebody who's on the receiving end, for example, of a DMCA takedown, a Digital Millennium Copyright Act, and wants to think through the questions of is it copyright infringement or fair use. So the vast bulk of the notices we get right now are from Google and Twitter, both of which give us the DMCA takedowns that they get as service providers. So the Digital Millennium Copyright Act sets up safe harbors for service providers who host information at the direction of users or who provide information location tools. And Google, through its hosting of Blogger, through its search tool, receives now more than 500 complaints a day on some days, demanding takedown of material that appears in blogs or in search results. And Twitter receives a smaller volume, most of it not alleging that in the 140 characters of a tweet somebody has directly infringed, but perhaps claiming that the tweet links to infringing copies of a work, or other times that there's an avatar image that's been copied without authorization, and someone demands takedown of that. Now, among these things, there are plenty that are, I think, within their rights under the law, making claims about infringing copies of musical works or movies or photographs, and demanding their removal. I think a lot of these, particularly around popular media, turn out to be relatively ineffective because the material pops up in so many different places that removing the links from all of the blogs, tweets, and searches that you see one day doesn't stop it from reappearing the next. And so my broader concern, and this is me personally, not the Chilling Effects Project, but I wonder whether we're putting more of a burden on service providers than is useful to society and even to the copyright holders who are making these takedown demands.
What do you think about that, Carolyn? About the burden on service providers? Should it fall more? Is it fair to assume the kind of the corollary of that the burden should be more on the individual's rights holders, or perhaps the individual who's uploading the content? What do you say about that, Carolyn?
It's interesting, and I understand for internet service providers that this is a onerous law. Unfortunately, there are so many anonymous people that are hiding behind domain by proxy registrations, and there's been some litigation about that recently, whether the not particularly the domains by proxy, but those privacy domain registrations, whether they have to reveal who is the actual registrant. But it is a way, and just like Wendy said, it's rampant. Copyright infringement is rampant, and I fight myself. Probably Wendy has some of my own DMCA takedown notices on her website because my blog gets completely reproduced. My articles that I've written get completely reproduced, I find, on other blogs that are driven by advertising revenue. And so I will send takedown notices for myself or for my clients occasionally. And it is a problem. It is rampant, but that doesn't mean that we should stop. And I found it, a little bit surprising that there was a classification of all DMCA takedown letters as a threat. They're not. They're an exercise of rights. They're not a threat. Just a request to take the materials down, because when I find my blog or my articles reproduced without permission, I'm going to try to use the DMCA takedown as one of the tools, as a way I can fight copyright infringement. And so it's not a threat. It's just a way to stop the reproduction of my work. A threat might be, if you don't take it down, I'm going to sue you. That's a threat. It's not extortion. It's legal. It's legal to say that if you don't do this, then I have the option of filing suit. But with respect to ISP, obviously there's so many takedown notices, but it is a cost of doing business, unfortunately, and I think that they just have to work that into their pricing structure.
Matt, what do you have to say about this? Are DMCA takedown notices threats? Do they do the job? Is this an area that needs reform? I want to ask you about patent reform a little bit later, but maybe to give us an appetizer to that, is the DMCA and copyright, this area of copyright, something that needs attention? What do you think?
Yeah, it clearly needs attention, but I think it's a first stab, I think, at developing an administrative process for dealing with unbelievable volume of easily reproduced information. I mean, we're in a new era now where, a service provider like a Google or a Twitter reproduces images at rates and numbers that just we could not fathom 20 years ago. And on their side, they immediately recognize that there's just this unbelievable burden to deal with that when people, when rights owners are upset. But it kind of gives them an administrative way to deal with it. I mean, once they get a takedown notice, I mean, they know how to deal with it. And it also gives the rights owners an administrative process to help them police the reproduction. They know where to go and where to send things when they find a reproduction on one of those services, and it gives them the tool to do it. It's certainly not perfect, but I think it's a first stab at dealing with these problems that just were not something that was fathomed 20 years ago. And it will change over time, not only to make the processes better, but also to deal with new challenges that are growing because of this technology. These are, we talked about the differences in technology on the music and the photograph side a little while ago, and these are just things that are advancing so rapidly, and I think they're putting these discussions in the forefront more than they ever have before. Technology is clearly driving the issues that we have to deal with. We've dealt with fair use, obviously, in the past, but not as much as we have here. I mean, the technology and the ability to reproduce things so quickly and to introduce subtle changes and to make so many copies, perfect copies of something so easily, is just advancing these discussions rapidly.
You're right, and that's one of the things that makes this area of law, whether you call it law and technology or internet law or cyber law or whatever, so fascinating, is that, the advancing pace of we're approaching the singularity. All of this stuff creates all these new issues and new ways to think about and stronger challenges, not only in intellectual property, in particular copyright, but also in areas of privacy and personal liberty. And I'd like to get into talking about some of those things and move out of our discussion of copyright law. But before we do that, I would like to say a few words about our sponsor of this episode, Netflix. This episode of TWiL, episode 124, is brought to you by Netflix. Netflix streams thousands of TV episodes and movies directly to you instantly, which means you save time, money, and hassle. There are several easy ways to instantly access streaming movies and TV shows with Netflix. You can watch Netflix movies and TV shows on your Mac or PC or iPad. I love the iPad app. You can watch on your iPhone and some Android phones too. If you have a gaming console, an Xbox 360, PS3, or a Nintendo Wii, you can watch Netflix right on your TV. If you're not a gamer, you can watch Netflix on your TV with an Apple TV box or Roku box. I have a Roku. It's awesome. They're inexpensive and easy to use. With Netflix, you can watch movies and TV shows instantly using any of these devices. And you can begin watching a movie or show on one device and then finish it on a different one. Whichever way you choose to access Netflix, you can watch as many movies and TV shows as you want, anytime you want. And you can cancel at any time. Try Netflix today for 30 days free. Go to netflix.com/twit. Be sure to use this URL when you sign up for your free trial. Once again, that's netflix.com/twit, as you might expect. We thank Netflix for their support of Twit and TWiL, episode 124, and we hope you enjoy watching instantly with Netflix. So that is, we've had a great discussion about copyright and some of the tricky issues, and as we were discussing right before the ad, Matt and I were talking about how, the advancing pace of technology and the approaching singularity, if you want to be dramatic about it, really presents all kinds of wonderful new issues, not only in intellectual property like copyright, but also in the question of privacy as well. And there is an interesting story, this is, quite timely to kind of frame our discussion about this, coming out of London. As we know, there are those terrible riots going on in London and in other cities in the UK that have been going on this past week. And, well, first of all, does anybody know exactly what they're rioting over? I'm having a hard time figuring that. Anybody on the in the conversation know what they're rioting over there in England?
It was something. There was a young man who was shot by police, and that's what caused the riot. And I think there was a racial inference there. It was racially based, the killing of this young man, and that has exploded.
Yes, and in the nature of how rioting is, you've got, thousands of people taking to the streets, not completely dissimilar to what we saw in Vancouver earlier in the summer, with the Stanley Cup loss, the Canucks lost, and, there was all that rioting in the street. And what's interesting from a law and technology perspective in all of this is the use of technology to track down the offenders, the people who are out there. And it's kind of the, across the pond kind of way of doing things, to have more surveillance video, more, I guess I live in Chicago, and so there's a lot of, cameras out on the streets now. But so maybe if you're comparing the USA and the across the pond kind of approach, take out Chicago in that comparison. But there's all of this surveillance, all these photos, both from the government and also people using social media to gather these photos. And so there's this interesting project that was short-lived. It has since been abandoned, of a group of folks who had started up a Google group. And their endeavor was to use facial recognition technology to help automate the process of recognizing who people are, so that they can be turned over to law enforcement. And so I'd like to start out with just some general questions. Matt, I'm going to go back to you on this. Does this freak you out? That's a term of art. Does this freak you out? And if so, what extent does it? The idea that technology is giving us the ability to recognize people just by the digital profile or digital aspect of their faces. What do you think about that at a very general, visceral level?
Well, I'll start by saying that in Ohio, we still get freaked out, to use your term, by red light cameras recognizing our license plates when we drive through a red light that we shouldn't have. So we're a little bit behind. We don't have the cameras recording our every move as we're walking down the street, at least as far as we know. But the red light camera has been a hot issue in Ohio for a while. But yeah, I have to say that it does freak me out a bit on a personal level. But I thought your introduction of the topic was interesting, as you compared us here in the U.S. To the folks over in Europe, and they've definitely moved ahead on that issue a lot farther than we have. And I think it's an aspect of their life now that every step they take down the streets these days is on if not one camera, it's on 30 or 40. And speaking not as an attorney, but as an individual and as a father and things like that, it freaks me out a little bit. If there's some sort of technology that captures my backside when something happens and somebody processes some algorithm and identifies me as somebody who did something when clearly I wasn't the one that did it. I mean, how do I cross-examine that technology, and how do I confront the computer or the algorithm that points the finger at me? So yeah, it's a little freaky. But if Europe leads the way, which a lot of times they do, I think it's something that's just going to be on the rise as we go forward.
There's another interesting aspect of this, comparison between us and with Europe, and this is kind of a related concept, I think, or at least I'll try to draw a connection between these two concepts and see what your reactions are. Wendy, I'll direct this to you, and this is this sentiment over in Europe, both at the level of the EU and also particularly in France, of this notion of the right to forget. You know what I'm talking about. Proposed legislation of having this information out there about you, whether that be on the web or in other databases, maybe not connected to the web, of a certain sense of, I guess it would come from an individual liberty perception or perspective that after a certain period of time, or if it's information that's not good about you, an individual should have the right to have that information taken out of the collective recollection of our society. And doesn't it I guess my thesis on this point would be, and the connection I'm trying to draw on this is, doesn't that seem a little bit paradoxical that, and I'm brushing with very broad strokes here, that we have Europe as this more focused on surveillance, gathering so much digital information about its citizens, but at the same time appearing to be aware of an individual right here to remain obscure or to be forgotten. Do you see any validity to that kind of connection, or do you agree with my perception of it being a little bit of a paradox, or is there some way to resolve it? I'm wondering if you could talk about that and what your perspective is, Wendy.
Somewhat paradoxical that we, unless we assume that these surveillance cameras are ephemeral and the moment that they snap the images, they disappear, it's hard to reconcile that with a right to be forgotten. And to me, coming from the United States First Amendment perspective, it's hard to reconcile the right to be forgotten with our own rights to remember, because while it's sort of superficially appealing to say we have a right to move beyond our past mistakes, the flip side to that, enforcing that as a right, would be a right to compel everyone else who remembers those things about you to forget them, and to take out of any public records or the public domain where they might be information that chronicles what was actual factual history at the time. And I don't think that we have a good way of doing that. And at the same time, we have to come to better terms societally with the vast amounts of information that we're creating and putting into random access storage now. That's, I think, different in kind from what we were able to do before all of our images and documents were digitized and available with the click of a mouse. You can now drag images into the Google search in order to recognize them. And while Google has not turned on facial recognition as a piece of that image search, the hints are certainly that it would be technologically possible to do that. And then how do we readjust our expectations so that we expect that to be happening, adjust what we do and how we present ourselves to the possibilities of all of that information being collected and recognized? And do we change the law to forbid reference to some of that information? I think we might have to. So while it's not possible to ask private citizens to forget information, it might be possible to tell law enforcement and corporate users of that information that beyond a certain point they were forbidden from using it.
You know, that sounds, really intriguing, and from a personal privacy kind of perspective on this, it would seem to make a lot of sense. But how would you meet a constitutional challenge to some kind of regulation like that? And the kind of constitutional challenge that I could envision would be a First Amendment challenge. You brought up the First Amendment right away. How would you articulate a compelling government interest in regulating that, or any compelling interest to justify the deletion and the non-use by law enforcement, essentially the non-existence of that information, against the right to free expression and having that out there? What would you say about that?
I'd say first that the First Amendment rights of individuals and of other types of entities should differ. So while corporations and governments do have First Amendment interests. I think that we should put those interests below the same interests of individuals, Citizens United notwithstanding. And I would then say there are important First Amendment interests in privacy as well. That the First Amendment protects our right to speak and to associate, and we will be chilled in those expressive activities and those social activities if we fear that everything that we do may be used in unrelated proceedings against us. Now, we'll have to work these things out, and I think a lot of the interesting aspects of privacy debates are what we see playing out as people become more experienced with new technologies, as we adapt the technology and our behavior around it to figure out what are the limits and how can we recreate zones of privacy and zones of publicity within newer spaces. To me, it's been fascinating to watch the way people have been playing with privacy on Google+, the latest social networking entry, and among the tech crowd at least, a lot of people seem to like it because of the different kinds of privacy settings that it offers, and to experiment now with how shall we change our sharing behaviors to match.
Right, which, incidentally does not affect at all the analysis of what Google learns about you in the composite and the responsibilities that it would have, vis-a-vis the rest of the world. But I want to, before moving on from this, I just want to examine a certain aspect of this a bit deeper. And this is something that you were talking about, Wendy, and characterizing it as fascinating. I certainly think it's fascinating as well. And that really is the philosophical underpinning of the idea of the justification for the privacy interest that an individual has. And the way I would characterize it or maybe present the question is as follows: does an individual have the right as to his or her identity and the subsequent uses of it, and how it is presented, and what databases it appears in out there in the ether? I mean, just this past week there was a pretty high-ranking EU official who was saying that essentially that a person should have the right to go out and manage this, which would comport with the sensibilities of having a right to forget kind of paradigm. Or should we look at it as thinking that all information, regardless of what it is, whether it's a predicate about a person or whether it's, the time of the sunrise or, the date that, Easter fell in the year 1742, as far as information as being something collective to our human heritage, should that belong to us? And those types of rights should overwhelm or override the right of the individual to have his or her identity made out there. Wendy, I just want to keep this with you. If you see the world in any thing resembling the tension between those two sensibilities, and if so, why? And if not, how would you critique a view of the world like that?
I think that the information that we're talking about is always social information to some extent, because if I can get perfect privacy by sealing myself up in a cave as a hermit, seeing no one and sharing nothing with anyone, but that's not going to be a particularly fulfilling life. And I don't think that we should force people into that degree in order to retain privacy. So how do we allow people to share information and yet restrict its use? By giving them ways to enforce the agreements, either sort of informal norms-based agreements that they make with one another when they go out with a group of friends, or perhaps by law saying, for example, when you share information with your doctor or your lawyer, you have privileges against its being disclosed out of context. Here I think of Helen Nissenbaum's work privacy as contextual integrity, that often what we want to control is the context in which information appears, and one of the reasons that I think digital information seems so challenging is because it breaks some of those context barriers. It's for the same reasons that we sometimes complain about copying of copyrighted works. We also can see easy copying of information that we might like to keep private. So we need to sometimes restate some of those normative boundaries, and where those aren't strong enough, I think, to bring in additional legal protections, so that we can share information without having to fear that it goes everywhere once it's been shared at all.
Right. I think of WikiLeaks when you're talking about that, and the radical distribution of information. Having these sensitive documents out there as torrent files. There's no way to put the genie back in the bottle. So, Matt, I would ask you then: is there a way that the law can actually reach this phenomenon of radical distribution and what Wendy was characterizing as, how the digital context breaks a lot of the norms about how information can be shared? Can the law effectively and meaningfully regulate that? If there's information that's out there and it really, once it's gone, it ain't coming back. What do you think?
I don't know. I think it's just going to be another problem of massive scale. Once the information is out there, whether or not a person has the right to control it or not might become a moot point once it disseminates and gets duplicated and over and over and over and over again. I mean, somebody who wants to remove some Facebook photos from their sophomore year in high school might have a false sense of security that they got them down off Facebook at one point in time, but 30 years later those photos might pop up somewhere else because there were 10 other copies of them sitting on a website somewhere that no one knew about. And trying to create tools to let people deal with that just seems like a real challenge of scale.
Well, copyright might come to our rescue, right, Carolyn? Because, if there's photos of you out there that are being published without your authorization, wouldn't it be okay to send a DMCA takedown notice to the host or to the provider? What are the sensibilities that would accompany them?
Sure. I mean, you can control a lot of images through copyright DMCA takedown notices, but the copyright owner or the copyright owner's agent is the one who has to send the DMCA takedown notice. So the person in the image doesn't have the right to send the DMCA takedown notices. But all of this comes back to an expectation of privacy, and photographers have been battling this, especially since 9/11. Or there's the idea of there's pedophiles out there taking pictures of little kids in parks, and there have been a lot of reports recently about photographers and taking pictures out in public of people and being harassed by the parents or by police for taking the photographs. But the law says that when you're in public, you don't have that expectation of privacy if you're out there. So photographs can be taken of you. The courts have said that most legal records are available to the public, although the courts now restrict, and then whenever you upload a file to a document, a pleading in a case, you have to make sure that you redact the private information. So the courts have set some limits on what's private, what's public, and we just have to continue to work through how do those expectation of privacy or those privacy concerns expand to us as new technology comes along, such as the facial recognition. So my argument with respect to going back to the facial recognition question, is that these looters are in the public. There is surveillance of the looters, and when you take they have no expectation of privacy. So when you take technology to try to identify who the looters might be, is it any different different than the days when maybe police, you see on the cop shows, you see the police officers going around saying, here's a picture of somebody, have you ever seen this person before? It's just on an expanded basis now. It's on the internet or through technological means that you can find the same person. I don't see that the looters have any rights that are being violated, privacy rights that are being violated. And going back to what Matt said, being a father, you may like the fact that a pedophile wants to be in your neighborhood is caught on tape taking advantage of a child, coming up to a child and taking the child off. We can use it to fight the crime. But you do have to go back to the law is, did the person have an expectation of privacy when you're surveilling them or taking their picture?
And I think that's a great point, because I've talked to a lot of people, about my age that have young kids and high school age kids and stuff, and not lawyers, but the theme that I hear from people is they don't know that they're talking about an expectation of privacy, but what they're saying is, what do you teach your kid about Facebook and Google and Twitter? And what I'm hearing that people are teaching their children is, you better be aware at all times of what's going on, because everybody you're with has a camera and a video camera in their pocket, and whatever they record can and likely will be posted to the internet somewhere. So to me, it seems like a lot of people have already kind of conceded that the expectation of privacy in a lot of situations is gone.
What is the responsibility of the provider when it comes to this? Wendy, you wrote a great blog post sometime in the last month or so that was talking about, I'm kind of adding this idea or this concept to it, or taking this concept from it, that there's a certain responsibility that the providers should have as to communicating and actually being honest with its users as to how much information is going to be available about them because of this content. And you were addressing specifically facial recognition technology and Facebook. Would you be willing to tell us a little bit your thoughts about the of the provider and the platform's role in all of this?
I think what I was saying there was that it's important for providers to disclose to users of their services what information is captured and what might be done with that information, because that's the only place that we'll learn to set our expectations. And so much of privacy, particularly in U.S. law, as against governments, is about the reasonable expectation of privacy. That applies specifically in the Fourth Amendment context as law, but it also applies to the normative context that we behave in ways that are shaped in part by the feedback we get about how private or public our actions are. And so those who are providing a social technology, I think, owe it to us to let us know how those actions might be perceived, how they will be shared, that lets us decide, okay, maybe I no longer want to upload photographs to Facebook because I'm aware that the faces of those people can be recognized automatically. Or maybe I'll take it back even further and think about telling my friends in the real world, please don't take photographs of me and upload them to Facebook, because I don't want facial recognition technology operating on my images. And if the provider isn't telling us about those uses, then I think it may be giving us false assurances of our privacy in those situations, or false understandings of what might happen with our information.
It sounds like the environment is suitable for the development and the use of privacy-enhancing technologies. And on this concept of privacy-enhancing technologies, there are entire conferences and symposia devoted to those things. And in fact, Wendy, you just attended one up in Canada recently, right? The Privacy-Enhancing Technologies Symposium, like the 11th annual. Didn't you go to that?
I did, up in Waterloo. It was a terrific conference with lots of discussion about the ways that we can use technology, particularly encryption and anonymizing networks such as the Tor project, to secure the privacy or anonymity of information exchange. So there are ways that we can leverage this technology to give us greater secrecy, as well as ways it's being used for greater disclosure.
It looked like it was a pretty esoteric conference. I was just browsing, the list of speakers and lists of topics, and very heady, high-level stuff. But did you identify any major trends, or something that you kind of bring down to earth off of the mountain and share with us as to what was going on there, what people were talking about?
Well, a lot of the work was mathematical and computer science analyses of the security assurances of systems, or comparison of ways of obtaining information. So, for example, there was discussion of location-based services and different ways of implementing location sharing services. So, for example, the provider might not have to know everything about where you were in order to report things that were near you, or to suggest a meeting place for you and a group of friends. There are ways that we can offer blinded information or fuzzed information, so that we aren't forced to reveal so much in order to take advantage of services. In other places, we can assess whether the privacy we're getting out of a system is as good as we're being told, or as good as possible, rather than just relying on vague assurances of, oh no, we won't disclose this information, but we might have to if we get a subpoena. It's possible to build in stronger protections so that we're not forced to give so much information in the first place, yet can still get useful service from another party.
So it sounds like technological solutions, technological ways to kind of ameliorate some of those privacy issues, which you might reasonably characterize as legal issues. Is that fair to say?
But I think that there are ways for providers to offer us greater technological assurance of privacy, and we as consumers should start asking more often, is it really necessary for me to give you all of this information? You look at what pops up when you're asked to install an application on an Android phone, for example. Do I need to share my contact list and my location information, or could I share less and still give enough to make the application useful? I think that the technology lets us share less.
Very good. All right. Well, I want to switch from privacy to talk a little bit about patent law. So, if there's nobody that wants to jump in with anything urgent that you have to say about privacy, just keep it secret. I will say that. Matt, you and I have known each other for quite a while. We've both been blogging for several years now. I remember the good old days back at Rethink IP. Every time we talk, I know I bring that up, the good old days when you were a collaborator on Rethink IP. So at least in my mind, you have always been at the real forefront of those who are commentating on the need for, just as the name of your old blog suggested, rethinking some fundamental approaches to intellectual property law. And you're a patent lawyer, so you spent a lot of your time thinking about that. And from what I gather, reading the news these days, there seems to be some exciting and rather definitive stuff happening in terms of patent reform. There's some stuff going on in Congress. Why don't you tell us a little bit about that and what your perspective is, and give us some of the highlights of things that we might need to be excited about when it comes to these things.
Sure. Well, no one can accuse patent legislation of moving too quickly. I know that much. We've been in the current patent reform movement, I'll call it, for 5, 6, 7 years now, and it's been kicking around Congress for at least that long. And it's had several ups and downs, and no matter which side you put yourself on as to whether we need reform or we don't need reform, I think everybody would agree that it's kind of gone up and down over that time and swung in both directions. But recently it seems like things are coming to a head on multiple fronts. We're still advancing a comprehensive approach to patent reform. We've never gotten away from that. For like I said, 5 to 7 years, patent reform has always been, in Congress, has been tied to this comprehensive approach, meaning that the people that are advancing it are trying to put forward a piece of legislation that doesn't just deal with one change to the patent law, but deals with several. At some point, more than a dozen major changes to the patent law. And we've never gotten away from that, even though the courts kind of dealt with some issues over those years that we thought would address some things. The current bill still sits as a comprehensive approach. Things that are in the bill that'll be changed include, the biggest thing is we'll change our system to what's called a first-to-file patent system. In the United States, we follow what's called first-to-invent law, and the way that works out is if there's two people claiming a patent for the same thing, we generally like to award a patent on that invention to the first person who invented it. But really, you have to say the first person who can prove that he invented it before the other person. And that ability to prove is costly and expensive, and the system for doing that has come under attack. And a lot of people have questioned the real benefit of having that system. You compare it, or you put that alongside the fact that the rest of the world operates under a first-to-file system, and there's been kind of a movement afoot to move us over to a first-to-file. So that's one of the biggest changes in the bill. And then the other thing would be, one of the other changes I'll call out will be what we've started to call post-grant review. And what that is in the patent community, there's kind of a running joke that the patent office issues invalid patents every Tuesday. And the meaning behind that joke is, well, the patent office issues patents only on Tuesday. But the reality of our patent system is this: patent applications are examined by examiners who, by definition, do not have access to every relevant piece of prior art. And all the examiners at the Patent and Trademark Office, despite some comments to the contrary, are doing their best to determine if a patent should be granted. And if the office grants a patent, it's entirely possible that there's prior art outside of their sphere that they were not aware of that would render that patent invalid. And without a post-grant review process, administrative process, the only way to challenge those patents up to this point and currently is through patent litigation, or primarily anyways, through patent litigation, which obviously is expensive and time-consuming. And a lot of people have thought, because there's not an administrative solution for that a lot of these, quote, bad patents that don't get challenged in litigation just kind of end up sitting out there, and they're never really taken off the books. So it looks like it's a valid patent on its face. Maybe one person knows that it's invalid because he's got the piece of prior art, but the rest of the world doesn't know. So the post-grant review process would put in place an administrative procedure handled by the Patent and Trademark Office that would allow people to more easily challenge patents without having to go through litigation. And it's modeled after some other systems. Europe has been doing a similar thing for a long time, and many people think it works quite well. So first to file and post-grant review are two of the biggest changes that are coming. And like I said at the beginning, we've been following this for 5, 6, 7 years, ups and downs. But recently, and when I say recently, I mean the last couple months, it seems like we're to the point where we say when and not if anymore. The House has passed its version of a reform bill, which has happened in the past. So that's not necessarily significant on its own. But the Senate has also passed its bill, and in this modern reform movement, the Senate has not done that before. So that on itself is a significant development. So we've got 2 bills that have passed. There are some differences between the bills, which means that we've got to work out the differences, or one chamber has to adopt the other chamber's bill. And it looks like the Senate has, just before recess, gone ahead and put a motion for cloture on the House, for consideration on the House bill, on their return in September. So the possibility that the Senate would move forward and just adopt the House's bill seems very real at this point. And then, I put a tweet up, I don't know, 2-3 days ago, which we've never had kind of a political side to this. Some people might disagree with me, but the politics of patent reform have been pretty. They've gone under the surface, I think, for the most of this until now. And this kind of hit me when I was watching the debt ceiling debacle, and I see Congress right now as they need 2 things desperately. They need to be able to show, quote, the American people, as they're so fond of saying, that they can work together in a bipartisan manner. And they also need to, on the economic things, they need to show that, they're doing something about jobs. The Commerce Department, a while back, did a comprehensive study of reform legislation, and the Commerce Department is a big proponent of reform, and they claim that this bill will lead to I've heard anywhere from 200,000 to over 1 million new jobs, because it's apparently going to unleash innovation from the patent that's currently being tied up by the Patent Office. It's going to unleash innovation into our economy by clearing out the Patent Office backlog, which will lead to hundreds of thousands and millions of jobs. So with that kind of analysis behind them, I think that it appears that it's a bill that now Congress people can put their name behind and say, hey, I'm doing this for jobs, and I'm doing this in a bipartisan manner. President Obama, who has spoken out on patent reform in the past, but he's said a few things recently that are quite strong, I think. He supports it and he wants it to move forward. So to me, it smells like the politics are kicking in, and reform is, I think, on the verge of happening.
Do you buy that when they say that it's going to unleash innovation like that?
Unleash innovation, or do I buy the jobs numbers?
Well, right. I mean, it seems to me there to be a strong connection between the sensibilities of the legislators who are saying that, faster processes in the USPTO, getting these patents issued is going to unleash innovation. It seems like those might be the same sensibilities and therefore the same people who would be in support of the Protect IP Act, which is, some comprehensive copyright legislation that really, could screw things up. Either Matt or Wendy, either one of you, what do you think? Is there any validity into this? I don't mean to use the word validity in this sense in a patent discussion, but any truth to this, or is this just all smoke and mirrors or a bunch of fluff? Wendy, what do you think?
I don't see in this bill the kind of reform that I would think would unleash innovation, and these are the things that dropped out earlier in patent reform's consideration, like a reform to notions of willful infringement and the treble damages available to against someone who is claimed to and found to infringe willfully. Reform there would, I think, do more to clear up the patent thickets problems that can retard innovation, because someone developing a new product can be found to infringe on dozens of other patents without ever having looked at the patents or at others' inventions. And if he's so much as looked at the patent or looked through the patent database to see what's out there, then he runs the risk of being found a willful infringer, rather than being encouraged to go through and look at prior art rather than redeveloping, or even to look through for things that might be worth licensing. Instead, the current system encourages an ignorance of what else is out there, and in many fields, there's no point to doing a patent search before developing a product, because it's no guarantee that you'll find the things that might get in your way, and could be more dangerous. So improving patent quality could help to encourage the innovation, but I'm not sure that the current bill that we have on the table will really do that.
Many people say that patent quality would improve if we did away with software patents. That's a very polarizing issue on this topic. Matt, is there anything in this or anything that you see that could be derived from it that would affect this question of whether software is or should be patentable?
I think software patents, it's going to be really interesting. If the bill goes forward in its current form and we enact it, it's really going to be interesting to watch software patents because, as you said, there's been a camp for a long time that said we should just statutorily carve software patents out of the definition of patentable subject matter. The bill is not going to do that, and politically speaking, it's not even on the radar. So I don't see that that's going to happen. But what the bill will do is it would create that post-grant review process. And software patents, it's a unique situation because, I was saying earlier that the examiners don't always have access to the best prior art. And in the more traditional arts, the mechanical arts that have been around forever, and even the chemical arts, the patent office oftentimes really is the best source of prior art. And the examiners have top-grade databases to consult when they're doing their searches. On the software side of things, the patent office is not always the best place of prior art, and the examiners might not have access to the sources that are holding that best prior art. So I think that is the reason why we have a concentration of the, quote, bad patents in the software area. But not ignoring, but putting aside the camp that has wanted to carve out software patents from patentable subject matter and just focusing on the group that says there's so many bad software patents, we need to do something about it. They might have something to do about it in the very near future, and it's really going to be interesting to see how that industry uses that mechanism. Because if they fail to use it, software patents kind of continue going forward as have, I think they might lose some oomph in their argument, so to speak. But they might be the one, on the flip side of that, they might be the ones that kind of define that process as we go forward, because they're the ones that seemingly have the best potential outcome of making effective use of that system. So software companies of the world might be the ones that ramp up on that process as it becomes available and kind of define it going forward. So I think that software patents will be an interesting area to watch if the bill is enacted.
Great. Carolyn, anything you'd like to add about patent reform or anything that we've talked about on this crazy patent law stuff?
No, I completely defer to Matt and Wendy and you, Evan. I don't touch patent law with a 10-foot pole. I refer out all those cases.
I know what you mean. So, well, great. Thanks for the discussion. Thanks for those high points, Matt and Wendy, for your thoughts on those. Well, every week on the show, we share with you a tip of the week and also a resource of the week. So this week's tip of the week is, Carolyn, I think this came from you, and Wendy, I know you were mentioning it earlier, and this is something I had no idea was a feature in Google Images, and it's one of those things that may have been like this for years, but I'm just learning about it, and that is using Google Image Search to find other photos on the web, other copies of photos of yours or any other photo on the web. Carolyn, how does this work? Tell us a little bit about this and how, if it's been useful for you or any of your clients.
Actually, it was one of my blog readers who shared it, or a client, I'm not sure, who shared this with me. And it's so easy. I've since used it to find a lot of images, both for myself and for my clients. But if you just go to Google Images, googleimages.com, I think is that the URL? No. Sorry, go to Google and then go to Google Images, and then if you've got an image opened also on your computer, you could just click and drag it and drop it into that search field that's normally a text field to find images, and it will do an image search for you. Now, this is just another tool that photographers and anybody can use to find images. And in fact, if you find an image that you like and you want to try to find the source of the image, the author of the image, copyright owner, you can often find it where the original source of the image is, and hopefully find the copyright owner and do proper licensing if it's not a fair use, right, Wendy? But there's a lot of other tools that are similar. TINEYE.com is another service that will do that as well, where you could just right-click on your image and usually find the image. There's some other images, other services like Digimark, other services out there that can be for free or for pay, but it's a very handy tool to find images out there. Just like you can find text searches through an internet search, it's now possible to find an image search.
Very, very interesting. Yeah, I was just playing around with it, and it's interesting to kind of divine what some of the data points are on the algorithm. It looks like color and even, faces. It looks like people, who'd have their head kind of aligned, positioned in a certain way. So it really is interesting, and I'm sure that there's a lot of common technological points with that and facial recognition technology. So very interesting stuff, and thanks for sharing that with us, Carolyn. Website called telldc.com, and this is a really interesting site. I'm not sure where it came from. I know Denise put it in the show notes for today, but this is it's a site, and it aggregates content. People can go to this site and ask questions of your elected representatives. And what it does is it collects issues and questions that are being asked. And, once a certain question gets a critical mass behind it, it's actually presented. A film crew is dispatched to the legislator, and the question is answered, and it's distributed, and it's tied very much in with various forms of social media, Twitter and Facebook here. So take a look at telldc.com. And if you have a burning question or issue that you'd like to get to your elected representative in Congress, for example, about patent reform, that would be a great one, or the Protect IP Act, or any of these things, telldc.com might be a great way to communicate that. Did anybody on the call here have any experience with telldc.com? Have you ever used it or known anybody who has? That's I just come across it myself, so it's definitely worth checking out and keeping on your radar screen. So, all right, well let's wrap up. Really been a great conversation. I'd like to just go around and say goodbye to everybody and remind where you can be found online. Carolyn, thank you very much for being on the show. Really do appreciate it.
Happy to be here. Thank you, Evan.
Yes. And tell us where people can find you online, how to follow up with you.
I'm at photoattorney.com. That's a blog and my website. I'm also on Twitter to some extent. I'm not super active. I use Twitter primarily as a way to quickly share items of interest, including your website, Evan. Great blogs, blog posts that will help my clients and blog readers about interesting tidbits of things happening with the law as it affects photographers. I'm Twitter photo attorney.
Great. And yeah, once again, your images that you have taken yourself, the nature photography and the wildlife on your site is just great. So it's worth the aesthetic experience going to photoattorney.com to check that out. So thanks again, Carolyn.
Thank you.
Matt, thanks for being here. Great to talk with you again. And where are you online? What's your destination of preference these days?
These days, I do most of my interactive stuff on Twitter, actually. So I'm at jmattbuchanan on Twitter. Personal website is jmatthewbuchanan.com or jmattbuchanan.com. And the firm website is bnip.com. And I've promised myself I'm going to work on Google Plus next week. So I've been kind of passive on that, but I'm hoping to get into that next week. So,
right on. Well, thanks for being here, Wendy. Thank you very much. Always a pleasure to talk with you. Like I say, I have so much admiration for your work. You're just really doing some great, interesting stuff out there. Where would you prefer to send folks online to learn more about your work and what you're doing and to follow up?
Thanks, Evan. It's great talking with you, and I've been blogging fairly sporadically at wendy.seltzer.org, and as well as publishing things at freedomtotinker.com. I've enjoy using services like Twitter and Google Plus, particularly to share information from conferences. So W. Seltzer, or following up on the great tips that I found someplace on Google Plus. If you go to wendy.seltzer.org/plus, you'll be linked over to the Google Plus account there.
Very fancy. Great. Well, thanks again. Thank you all thank you all very much. Again, I'm Evan Brown. I'm at internetcases.com, or you can find me on Twitter at internetcases. It's been a real pleasure hosting TWiL, 124. Wow. So Denise will be back next week. But thank you very much for tuning in. I sure have enjoyed it. So until this same time, 11 Central on Fridays is when we record. Also, you can find the episodes in iTunes, on YouTube, and also at twit.tv/TWiL. Thank you very much. Talk to you all soon.